this is where I think all the lawyers are going to be scratching their head a
Mhm.
little bit. And I think there's really good arguments on both sides here.
We're the Armed Attorneys. Today we're talking about arm braces, and we're going to talk about whether or not we think that the courts will grant injunctions such that the rule doesn't go into effect. You do not have to yet register your arm brace and AR/AK pistol as a short barrel rifle. Our opinions are worth what you're paying for them right now. But I hope you enjoyed the segment. Before we get started, show your support for the Second Amendment by hitting the like button. Richard, want to start us off?
Yeah, so we've got this question quite a bit, and I think this is just kind of a practical question everyone has in their mind. Hey, the ATF is making their move on pistol arm braces. We see in the wake of New York State Rifle and Pistol Association v. Bruin, this new standard by which we judge these infringements on the Second Amendment. We see this bump stock controversy and how the courts are kind of reining them in, also in the wake of that decision. And are these things actually going to get prohibited or treated like short-barreled rifles? And what do I do just if I'm a normal person? I mean, the numbers I've seen are tens of millions of folks that have arm braces out in circulation. And so do we think the courts are going to push the pause button on the ATF, essentially say, hey, look, you're coloring outside of the lines here, and what the chances of success are? And I think there's kind of a good discussion to be had here to help people.
Yes, and I think we can rewind back to 2016 when I was horribly wrong about bump stocks. And I said to everyone and anyone who would listen, the courts are going to enjoin this. It will never go into effect. Don't do anything with your bump stocks yet. The courts are going to never. I was 100% wrong. I still think I should have been right, but I was 100%
You would have
wrong.
been right if New York State Rifle and Pistol were there.
I should have been right before that
Yes,
because
okay.
it was an unlawful taking and it was not within the definition. Anyway, that's a different video. But we do have Bruin now. And not only do we have Bruin, but we have Cargill's case, right? In which the Fifth Circuit has finally done the right thing for bump stocks and saying, number one, bump stocks don't meet the technical definition for machine gun. Number two, the rule of lenity says it's ambiguous. We have to interpret it in the favor of the potential criminal defendant. And so, you can't do this. You can't regulate this way. You can't take these away. What do we think? How does this all apply to SBRs? And I'll tell you, it's a good question, right?
Yeah.
So I think first we talk about, is it in the public interest, Richard, to go ahead and have everybody, given that there is amnesty, right? There's $200 amnesty. Is it in the public interest to go ahead and have everybody register these items? What do you think?
Yeah, probably not the way that the court would evaluate it. There's just too many people impacted and the financial burden placed on normal people. I think that it would not serve a public interest in this particular circumstances. Bump stocks, that argument wasn't as strong because it wasn't as common use. So I think we have a strong argument on behalf of whoever's suing the government. I think they have a good argument there.
So that's one standard for when you should grant an injunction. There's factors to play, and that's one factor. Another factor is, what kind of irreparable harm is done to people if you do not enjoin the behavior. And here, we have, I think the government's going to be screaming to the rooftops, there's amnesty. There's amnesty. You do not have to pay the $200. No harm, no foul. Forget about it, which is not realistic,
Yeah,
right?
and the other thing that I think that undercuts gun owners in this particular circumstance, unlike the bump stock, and this is how it was with all machine gun parts, a single part itself was treated as a machine gun.
True.
And so if people wanted to comply, they had to dispossess the item. Here, I think people can comply just by removing. And so I don't know that the harm there is as strong.
Right. And, of course, we all know, like, let's say that you are going to go ahead and register. That's how you choose to comply. Even without the $200, you still potentially you want to get a trust, which means you're going to pay a lawyer, and that's more than the $200. Maybe you're not going to get a trust. You're just going to go at it as an individual. I don't think the government's that sympathetic to like just the loss of your time.
Right.
But I am because it's a big process.
Yeah.
But, that's something I don't think the courts will be that sympathetic to that argument. But let's talk about the likelihood of success on the merits, because I think really that's what this is going to come down to.
Yeah, so public interest greater, damage less, high likelihood of success. This is where I think all the lawyers are going to be scratching their head a little bit, and I think there's really good arguments on both sides here, because we look at the Fifth Circuit, we look at the Michael Cargill case, we go back to that case. Why did they win in that particular circumstance? Well, the court said, hey, you know what, ATF, you did not meet this technical definition, that Congress prescribed for machine gun. You lose there. But they even have this fallback on lenity. You created this ambiguous law. So even if we're not going to go with our first argument or our first finding here, we are still going to fall back on lenity. Now, looking at the technical definition as far as machine gun, I mean, they went hog wild on machine guns.
Yes.
And
there was nowhere close to the technical definition.
No.
This is closer.
Yeah,
right?
That's the part that, gives me a little bit of heartburn, because we look at our original definition of rifle that we have in the United States Code, that we have in the Code of Federal Regulations. They're identical up until whenever this rule gets published. And now, why are they more similar?
Well, what we've got is, you have this is not the full definition of rifle, and it's not the new definition, but, when you sort of have your definition rattling around in your head, it is something that is intended to be fired from made or intended to be fired from the shoulder. So, we all know that everyone out there with an arm brace has only ever used it as an arm brace, Richard. Right?
Yes, 100%.
100%.
I do. I did have a disabled client call me the other day, and this is, I don't want y'all to take our sterile kind of tearing this apart as we are
as
not
an endorsement.
as we think the ATF's doing a good job.
Yeah.
Or, I'm very sympathetic because I actually have disabled veteran. He's a disabled veteran.
Yeah.
We have actual clients that this is going to affect, and the ATF doesn't care about it.
No, they don't care.
No.
And I'm sympathetic to doing what you can to get around the government, make better rules, right? If you are, in fact, using the arm brace to shoulder the weapon, it looks like it's intended to be fired from the shoulder because that's exactly what you're doing with it.
Yep.
And of course, the bear, does not meet the 26 inches in length. And so they have a better argument than they did with bump stocks that this item actually does meet the technical definition. Not just that, but since we're talking about likelihood of success on the merits,
Yep.
We have to talk about lenity. And to talk about lenity, you have to talk about ambiguity, because you don't get to lenity without ambiguity.
I think we got ambiguity, though.
You do?
Yes.
I'm not sure. So we have a lot of what they say are objective criteria that we really know are subjective.
Yes.
I'm not sure that judges who aren't gun people necessarily look at it and think it's ambiguous, because when you just read it,
Yes.
it looks like they've made a good case for what they're doing. You have to really know the ins and outs and all of the different products and what everything looks like to see the ambiguity. Do you think that gets conveyed to the judges?
No, and I think, and maybe there might be another argument that we didn't see in the bump stock cases with meeting some of these due process requirements, because while we build in this ambiguity, which I think we do have a little bit, especially on the marketing components, I think.
Marketing component, sure.
But when we say, hey, we're going to judge what you have as a short-barreled rifle based on what we saw some random YouTuber do, that not only do we implicate ambiguity, which I think we do a little bit, we really bring in some due process stuff. How am I supposed to be on notice that
how are people actually using it in the community? Yes,
Yes.
that one is totally ridiculous.
So
and again, I'm the things I'm saying, I don't want them to be true.
Right.
I mean, in part, we get paid to be pessimistic, to look at worst case scenario, right? That's what we're here for as attorneys. The pessimistic part of me says, and I'm not saying that you don't win ultimately on, just agency overreach. I'm not saying you don't win ultimately on Bruin issues. I don't know that we get the temporary injunction granted, particularly because we don't have a final answer on bump stocks. We highly suspect, I know in my heart, the Supreme Court's going to take up bump stocks.
Yep.
But we don't have that final answer yet. We still have a circuit split. So that doesn't really lend yet to likelihood of success on the merits. I'm worried. I'm worried this rule goes into effect.
Yeah. And what would give me less heartburn is if the, Fifth Circuit in the bump stock case said, hey, we're going to rest our hat on, like the EPA case, major question. We're going to hang our hat on, this violates Chevron deference. We have an agency disagreeing with, the Congress. They kind of do that. They don't drag Chevron into it. But, if we had some more material there, and I think if those arguments maybe get made that probably might offset some of this. But I want to hear what y'all think in the comments section. Go ahead, post your prediction now, and then we can revisit it whenever we get there.
Well, because I think we're split, right? Because I think my final answer is injunction doesn't get granted. This goes into effect 120 days after it gets published, and we're stuck until there's a final resolution. And you, I don't think, agree.
No, I think we see an injunction granted. I don't know that it's going to be as wide-reaching. It may not. I think it's going to be so small, this affected area. Maybe it's going to be the Fifth Circuit. Let's say it's in one of these places. I don't think we're going to see folks all over the country treated differently. So it's going to depend on where you live. That's kind of what I think is going to happen.
Interesting.
But we hope you enjoyed this discussion. If you did, subscribe, hit that like button, and help us fight the anti-2A algorithm. It's out of control right now by sharing this video.
Yes. And please let us know what you think about our opinions. Otherwise, until next time, we're the Armed Attorneys.
That was good.